the Secrets of Asset Protection. My name is Douglas Lodmell, and today I'm going to answer one of the most common questions that I get all the time. What is offshore? Is it legal? And how the heck does it work to protect my assets? So first, let's look at the topic of offshore. What is offshore? Well, for us as United States citizens, anything that is, say, a family in Paris on a vacation is offshore. Now, what about offshore money? Well, the money they have in their wallets is offshore money. And there's nothing illegal, immoral, or prohibited from having all of your money, some of your money, any of your money offshore. This is one of the freedoms that as Americans we enjoy. So how does that work, and why would we want to be considering offshore at all? Well, let's look at onshore. Onshore for us is anything within the United States, which, by the way, if you're not a U.S. citizen, anything within the United States is offshore for you. And believe it or not, the biggest tax haven in the world is the United States. In fact, there's more money here that is offshore that is being used for a tax-advantaged investment than anywhere else in the world. The Japanese, the Chinese, all of Europe, they invest here because for them it's a tax haven. For us, very important to understand, offshore does not create a tax haven. And that's because of our IRS code and because of the fact that we tax on worldwide income. Most other countries do not do this. So really want to separate the offshore legality from the tax offshore illegality. So let's look at onshore. Well, first of all, we're currently in what's considered a lawsuit lottery in the United States. The reason why is that we have an out-of-control legal system. Over the past 30 years, the plaintiffs' attorneys, the trial lawyers, have systematically changed the four fundamental cores of our legal system. Now anyone can sue anyone at any time for any reason. You don't have to prove your case before you sue. You can get an attorney for free, and since there's no loser pays system, it doesn't matter if the plaintiff or the person suing you loses, they don't have to pay you back. What that means is if you run up $100,000 of legal bills defending a lawsuit, you're out of luck, even if you win. So the question is there a way to protect your assets? And if there is there any way to use offshore as a part of that? Well, the answer is yes. Let's take a look. First of all, the very strongest, very best legal entity for asset protection, onshore or offshore, is a trust. A trust is comprised of a trustee, holds property. It's a legal entity established by someone called a settler who settles the trust. It's established for the benefit of a beneficiary. That's the person who's going to receive the assets of the trust. Now, a trust can be established at any time for any legal purpose. You just can't establish a trust for an illegal purpose, but any legal purpose is completely fine. Number two, it can be established in any jurisdiction. That includes inside the United States or outside of the United States. Again, as long as it's for a legal purpose. So the question becomes, well, what's the best jurisdiction? And the follow-up question is asset protection a legal purpose? Well, the answer to the second one is asset protection is absolutely a legal purpose. The courts have recognized that you have the right to take preventative measures to protect your assets. What you don't have the right to do is convey your assets after you have a problem. That gets you into the fraudulent conveyance area. But as long as it's done before you have a problem, you have every right to establish whatever planning you want to protect your assets. So, our first question, what's the best jurisdiction? Well, we know the United States, no loser pays system, contingent fees, lawyer for free. The complete system is now run by the trial attorneys. Let's see if we can do better offshore. I'm going to look at an offshore jurisdiction, and this one is called the Cook Islands. They were the first to enact what's called a Trust Act. This is a very specific statutory act that was designed to allow a settler to create a trust. So let's see what the Cook Islands Trust Act has in it. Number one, no contingent fees. So unlike the United States, in the Cook Islands, if you want to sue, you better get out your checkbook. Number two, no recognition of any judgments outside of their jurisdiction, which means no recognition of a U.S. judgment. That's good. Number three, loser pays. They've changed the rules. You go to the Cook Islands, you sue someone, and you lose, you're going to pay them back all their legal fees and costs. So it can get expensive for you to try. Number four, the burden of proof. Now this is a big issue. Burden of proof runs anywhere from preponderance of the evidence, which is 51%. So if you just have to be 1% more sure that it's true than not true to find someone innocent or guilty. All the way up to beyond a reasonable doubt. This is the murder standard. This is the very highest standard. This is what you would consider 98 or 99% sure. Very hard to meet this burden, as I'm sure we all understand. The burden of proof in the Cook Islands is beyond a reasonable doubt, even for a simple civil matter. So very high burden. Number five, specificity of claim. This is really critical. In the United States, the way the legal system works is the lawyers can sue, not really be sure if there's anything that they really have a cause of action over. They can get into the discovery phase, and then they can amend their claim and change it all they want. And many times, the claim looks nothing like the original claim. Not in the Cook Islands. You got to say exactly what it is. You have to file an affidavit, and then you're locked to that. If you discover anything new during your discovery process, you've got to file a new claim, if you can, because the statute of limitations is running there, as you'll see. Number six, the plaintiff, the person suing, pays all of the court costs and fees, everything. So again, very expensive to come down to the Cooks and start a lawsuit. And number seven, the creme de la creme, a hard and fast 2-year statute of limitations. That runs from the time that you settle the trust, right here, from the time you create it, and fund it, which means that you actually put the money into the trust. So let's say they start a lawsuit, the statute of limitations runs, they find the real claim, they can't amend it. Bottom line is that it's virtually impossible to get success in suing trust in the Cook Islands. So far it hasn't been done. There's been attempts and no one succeeded. So it's an incredibly strong jurisdiction and an incredibly strong way to hold your assets. Now, what does this really do? It really puts you in the position to negotiate, and to settle, because you're no longer subject to the dysfunctions of the U.S. tort system. You're not just sitting duck anymore with your assets just hanging out there. So the key with it, as with all planning, is that it's got to be done before there's a problem. This is the critical thing. But as long as the waters are calm, you can absolutely use offshore to protect your assets, not to avoid taxes. Doing an offshore plan will not save you a penny in taxes. You'll still get a K-1, you're still going to pay all your taxes on any money that you earn. But it does absolutely protect your assets. I hope this information has been helpful to you. And remember, information leads to understanding, understanding leads to clarity, and clarity leads to power. Take the power.